for this last session of Women in Law. And so we will start with we'll just have that little change around and start with my session, which is a recorded session. We might have more time for questioning, or the other speakers may turn up. So I'm Pauline Collins from the University of Southern Queensland in Australia. And it's very cold and dark and wet here at the moment. I'll leave anything else to when we have the discussion, but please post any questions as you go along. So Bonnie, if you want to start the... Hello, my name is Pauline Collins, and I would like to thank Professor Michael Lower, Vivian Chen, and the organising committee at the Chinese University of Hong Kong Law Department for organising this amazing online conference on teaching and learning in law. And I'd particularly like to thank the Stoic Stayers for their presence at this presentation. Today's legal practitioners are adjusting to a different type of legal professional practice that requires a very different style of lawyering. This new professional is required to use communication not as a strong partisan advocate, winner takes all, but rather to advance their client's interest in a holistic and a collaborative manner that sustains relationships and satisfies wider interests than just monetary ones. McFarlane has described it as a seismic change from adversarial advocacy to conflict resolution advocacy. The dilemma for the law student is that much of their law school curriculum still focuses on adversarial advocacy. A further dilemma is the perpetual divide between doctrinal or theory and skills teaching. Despite being well documented, this is a false binary. This can present as a major block to adoption of a holistic approach to teaching dispute resolution in a law school and makes the task of the dispute resolution teacher so much harder. Adapting to the collaborative over a rights-based communication approach can be very difficult. It requires both allowing greater ownership in disputes and their resolution by the parties, as well as a recognition of the importance of needs and interests beyond mere rights. Students have likened the difference in approach as to wearing two different hats. Encouraging lifelong learner skills and preparing students for a new style of lawyering in the 21st century to meet these changing needs means teaching in renewed ways. This presentation will describe the action reflection learning approach adopted when teaching a dispute resolution course. As a female professor, I tend to adopt unique assessments, and these I find indicate a style of teaching that bridges the false divide between doctrine and skills, but more particularly adversarial and collaborative legal training. My experience is this has enriched the students' learning. However, it is not without its challenges in satisfying the many masters in the current law school and university environment. Australian law students are required to attain a threshold of learning outcomes called TLOs. There are 6 of these, and TLO 6 is called self-management, and this requires a reflective capacity as a core skill. It is expressed as an ability for students to reflect on and assess their own capabilities and performance and make use of feedback as appropriate to support personal and professional development. This is an interesting requirement in law curriculums as those curriculums we all know allow little space for ensuring the time needed to engage students in both action learning and assessment and reflective practice. And this is despite the acknowledgement from the TLOs of the necessity of this skill. Even calling it a skill throws up the dilemmas as it raises the aforementioned perpetual division of doctrine and skills teaching. And much has been written about the hierarchical division between the heroic doctrinal teacher and the lesser vocational skills trainer. In the US, Jewell has described how this reinforces the development of doctrinal professors on one level, aiming to distinguish themselves from the earlier vocational professors who were often practitioners and now seen as clinical legal skills teachers. This has been written about as a gendered problem, with the vocational skills trainer being seen as lesser in the hierarchy and a position often filled by females. I see this a little differently, interestingly, as a female professor, but also a practitioner mediator. I'm teaching a first-year undergraduate course that has both theoretical and skills combined approach. I guess some of the discussion, though, is borne out when it's considered that I'm the only female professor in the school still teaching a first-year core course, often referred to as a skills course. However, I integrate doctrinal theory along with the skill development, approaching the teaching as a praxis, that is a holistic integration of what to do and why one is doing it, and understanding the theoretical consequences and import if one is not doing as one should. The research done by Schultz and Zedek in the US on law school admissions, which was based, much as in Australia, on an academic proficiency or merit score, provides another avenue for considering the law school role. Schultz and Zedek propose a better professional competency scoring process that has greater predictability for producing more competent and professional lawyers. Their extensive research showed that an ability to address 26 lawyer effectiveness factors was essential. These were focused, guess what, around communication, which is something that dispute resolution teachers engage with extensively. And they included areas such as ability to listen, self-organise, manage one's time, creating healthy relationships, and being able to use empathetic abilities. And these all provide for a more successful professional lawyer outcome in their findings. My course supports a self-management approach in learning that enables students, by adjusting after feedback and reflection, to appreciate the development in their capability and skills, such as listening, communicative ability for better relationships, and acknowledging of emotions. Thus, it attempts to satisfy the TLOs and the professional accreditation master's demands. As noted, the teaching in legal conflict resolution approaches skills and theory as holistic, single, not disparate concepts. While this would appear to require students to be present face-to-face, we have enabled online participation in role plays. Assistance teachers are generally required to circulate and ensure all participants are receiving appropriate guidance and feedback in a role play activity teaching session, whether that be face-to-face or online. This is seen as creating a more expensive resource-intensive course, because if the assistant is paid, it will cost more. However, often they do it out of love and just assist. But economic efficiency is obviously one of the requirements of the new university. So these realistic role play scenarios enable groups of 3 students to perform mock mediations. 4 mediations are conducted of around 90 minutes each over a period of 2 days. And this goes beyond problem-based learning that relies on adopting solutions centred on past experience to instead follow an action learning, acting upon reflecting, simulating simultaneously their learning, but requiring reflection on practice both during and after the activity. So action reflection learning allows assessors to set tasks that incorporate the elements of reflection, include some form of real problem. So sometimes it can be misinterpreted as problem solving, but the experience has to relate to the participants' professional context, multiple participants, a range of potential responses, and mostly for reflective learning, the opportunity for reflective action, both individually and in the group, and with an action expert learning coach. Of the 4 schools up there on the slide of action learning, the latter is adopted in my law course, namely critical reflection. And this is because I like Frere's notions of praxis, in which practice is purposefully integrated with the theory, and that supports my approach. Critical reflection involves addressing the context in which the problem arises by challenging assumptions, encouraging alternative approaches, and inducing an empathetic appreciation of the consequences of action as they affect outcomes and other parties, a requirement that has been noted by Schultz and Zedek as in greater need for law practitioners. Rogers has there given a 4-step guide to reflection, which I won't go through. Each of these aspects are present for the law students when learning a new communicative process through active application in a group mediation role play. The group reflective exercise brings together people who have a shared knowledge, goals and attitudes that support student learner self-assurance using the knowledge achieved by action reflection and this can result in a change of behaviour and ability to lead and adapt to change as the approach instills a confidence in students' ability to transition to professional practice. So the assessment in this course attempts to accommodate these demands. With these in mind, the role-play mediations challenge students that have been put through a scaffolded, structured, prior learning experience, starting with the relevant theory, then learning the mediation process, and then these come together in the final combining of the two in the praxis. There are a number of opportunities for reflection that are provided at least 3 points throughout the course. One of the main assessment items is a reflective written assessment worth 35%, requiring the students to document and respond to 2 or 4 role plays occurring over the 2-day intensive. Having learned the theory, process and skills in the scaffold of prior sessions, the students are required to identify how this informed their experience by reflecting on the links between theory and action. Whoopsie. Okay, not sure what happened now. Might have to ask for some assistance. Otherwise, I think we were close to the end. So is Bonnie around to help us? Otherwise, we can start with some questions. That might have been my fault. We may get an earlier minute than we even thought we would. Which it's getting close to dinner time. Michael, are you? No, I have Mitsu, so we have our other speakers arrived.
I do have some questions, Pauline.
All right, look, I'm sorry that got cut short, but I see that Mitsu has arrived. Hi, Mitsu. We just started with my session first, as you weren't here. So and my recording sort of cut out, which is a pity, but that's technology. We are adaptable.
But so, we could restart the recording maybe to where it was and just switch the settings around.
Yeah, I don't know if, you know, they can shift it, Michael. So maybe, you know, it was just meant to be. And you know, the recording is available. So if anyone is really keen, I can email the recording to them anyhow for the final bit.
But should we do the questions anyway? Because
yes,
Mitsu could take your session and.
Yeah, we're swapping around. So we'll do my questions now. And then we will be on time, so that's fine. We're a bit earlier anyhow because that finished a little bit earlier. So Michael, your questions.
Well, I've got several. I'll ask one because other people may also have questions, but if there's space, I've got quite a few really. Let me just start with the first.
That's worrying.
And the first one is just to say my interest, and we've got a shared interest, is in communities of inquiry and action research. And of course, we're both interested in communities of practice. Now, so here's question number one. In your talk, you said that about self-management is a skill, okay? As if kind of saying it's not intellectual. But what I wonder is whether, in fact, at least one strand of this self-management is metacognition, you know, a theory of yourself as a learner. And so it's not just a skill, it's got a cognitive, intellectual element and a theoretical element, which can, and then students can be introduced to the theory And so that adds a dimension.
Okay, so that's all right. I thought you were going to give me a list of questions, but
Well, I've got lots, but other people may have some.
No, that's all right. That's one at a time. And look, I think you have interestingly honed in on a total aspect of what I'm talking about, this false binary. And there's been a lot of that discussion throughout this wonderful conference about, you know, skills, doctrine, theory, principles, and, you know, the yin and the yang. But you know what? We're all human. So I see it as the whole person and holistic. And when I talk about, you know, being the female professor and you're seen as the guru, that you can impart your knowledge to the others. And, you know, it's for some often females to teach the bulk classes and the skills and so forth. I have tried to combine them and treat them as one. But what you've picked up on is in the threshold learning outcome that has been written by law academics for lawyers, and they talk about self-management as the threshold learning outcome number 6, and they talk about it as skills, and these are often referred to as soft skills, etc. I have just taken, okay, well, it's the threshold learning outcome of self-management that I'm dealing with here, and they call it skills. But you've pinpointed what I have probably intuitively done, that I am saying it is much more than that, that it is a metacognition, that it is learning about yourself and reflecting on how you speak, because we're in dispute resolutions, we're in conflict. So we actually also teach conflict theory, which interestingly in a law degree doesn't get a look in anywhere else. And yet they see dispute resolution courses or dispute management as skills kind of courses. No, they're not. They're heavy in theory, and they're heavy in the theory of communication, of which there is a lot of theory out there, and conflict theory. So we also look at the theory of conflict. And what the students get to experience through this action role play learning is they reflect in the moment, because they come into it and they go, oh, it's just talking, Pauline, you know, that's intuitive. We don't have to learn about that. And then they have to actually be careful about the words they use, the language they use, body language. We haven't talked a lot about body language, but that's something over 90% of communication and is really interesting when we're talking about technology and so forth. So, yeah, I won't go on too much longer, but I think you really did hone in on there that, yes, it is theoretical, but the skills that the law overarching TLOs have called it a skill. It's much more than that. So I love that you said that. Now, Michael, there is a question here from Esther. So perhaps if I just go to that, because I should stop at 7:50. So we'll see how we go. Oh, that's in my language, my terms here, sorry. So Esther's question is, I would have a question in relation to the resources for the simulated exercise. Is there any way to use higher year students, if any? We did this in torts for client interviewing, and it was a great experience for both sides. I'm not sure how it works for dispute resolution, but for client interviewing, the higher year students gain so much from standing in the client's shoes. That is absolutely it. This is a first year course, although it has some JD students in it as well, but it's held in the second semester. So they've had one semester of law subjects, usually four subjects. The students actually role play. That's what I'm talking about action reflection learning, because they actually act out a role. So some of the best learning they get is from actually playing a client, not actually playing the mediator, but they get to swap around. So they get experience as a mediator and experience as a party. And some of the best learning they get is actually, well, when that person said that, or when they did that, or they weren't looking at me and they were looking more at the other person, that made me feel they were biased. That upset me. Are we still working? Yes. Because it looks like Michael's frozen. You know, that's learning that you never forget. I have students come to me years after they've done the subject and they say, I never forget that because I was in it. And so they go into it thinking, oh, how hard is this? Like, you just sort out this dispute. You just bang their heads together like good lawyers do, because you know what the solution is, being great problem solvers. And it's like, oh, no, you've got to sit back. They've got to come to their own solution. And they find that extremely hard. They describe that as wearing two different hats. And then they look at you and they go, oh, my God, this is really problematic. And unless they'd have actually got into that and felt that, they wouldn't have, it would have just gone over their head. So there's a place for action and there's a place for reflection, and it's not much in law degrees. As a speaker was speaking in the other session, that's Simon Bruman and Sarah Stoke. They were talking about reflective, but they were using it in a different way. But there's room for a lot more of that in the law school. So, Michael, did you have one more question? I think we've got a little time. So, but your voice is off. Yes. Just your audio. Or you could type it. If you can type quickly. Anyone else? And we will shortly come to, so it's probably a bit odd that I was in this session, but because it's about women in law, but I am a woman in law, so the real thing. I've been
unmuted, Pauline. I was going to point out, I was in the Simon Bruman session, and obviously there is a commonality there. I wonder as well, assistants, you said that they do it out of love, but that you couldn't count on that. But maybe older students could do it as some kind of service or even for credit, I was going to say. And so that kind of might square the circle.
Yes.
I was also, sorry.
Mm-hmm. Keep going.
Well, I was also going to say, you're talking about action learning. I'm interested in action research. I think they're slightly different, but obviously very common. They've got things in common. But this is one thing I think, and I know we've got this common interest. So we've both been going to these sessions about communities of practice for educators. And so I think, my question here is, what do you think is the commonality between your reflection that you're asking students to do and the action, and your action learning theory, there, and then the the reflection that takes place within communities of practice?
Absolutely.
Particularly if I think communities of practice should be, for teachers, should be driven by action research. Teachers doing, as we're doing in this conference, action research, reporting to each other.
So thanks, Michael. Great questions. I think there's 3 points, and I'll try and get to them, and we'll be finished on time. First of all, action is really just putting the body in it and experience it through all 5 senses, if you can even taste. So students have food at their role plays if they need it. They have coffee. We have all of that. And as does community of practice. And community of practice is very much around food and communication. And I think that comes back to the topic of women in law and how we personally influence the way we teach, the type of assessments we set. And so I think I have given the students this reflective action learning because that's what I like. I am a reflective practitioner.
Is what you're saying there that somehow
exactly
there's something female about, more embodied about?
I think it is. I think it is. I think it's reflection is about being able to say you're wrong and to angst over something a little bit, to chew its edges a little bit. And I think that maybe at the risk of saying it's a gender thing, I think there is enough literature to say that's the way women perhaps behave, but men will too. Men are great reflectors, and you are an example yourself. I will just quickly answer that other part of your question. The first part, because we're coming up to the time, is I have done that exactly because I was told by my head of school, your course costs the most. It's too expensive. And I'm thinking, well, hang on, the students are paying a fortune. My course actually doesn't cost that much. But yes, it does cost a little bit more than the others because I have some food. I'm allowed a budget of $50. It hasn't changed per 2-day intensive to buy them some lollies and tea and coffee. And that can be, you know, up to 30, 40 students that like to eat a lot. I sometimes feel like Jesus dividing the loaves and fishes, but I have resourced prior students. So yes, students who have a passion for my course and who show that they're really good at it and who I've mentored into the industry where they've become mediators and the like, they love or want to become teachers. They love that opportunity to come along and assist by going around the role plays and being a coach who can model the language and model the communication that is required. So I have done everything to cut my course so that it does not you know, get cut entirely within the new university where resources matter. And with technology, this is also done online. We do that as well, but obviously we can't put the food down the line. So we encourage students to have their own coffee and all the rest. So yeah, so I think I'm probably at time now. So if, you know, so we can continue discussing that perhaps in community of practice or wherever, but well done and congratulations on a fantastic effort bringing this together, this conference.